This is Alexa Cunningham versus Maxwell doing business as Round Rock Nissan. Retrial matter. We got a petition, we got an answer. Limited discovery, motion for continuance. Retrial of parties. Might need to amend the petition. All right, let's take a look. Mr. Starling, I think you were wanting some more specificity from the plaintiff's pleading.
Yes, Your Honor. And more specifically, what we were looking to do is in our answer, we included a motion to conduct limited discovery. This case centers around a vehicle that Ms. Cunningham purchased from Round Rock Nissan, and she alleges that the vehicle has a manufacturing defect, essentially, that it's making some strange noises, and it's essentially, I don't think she says she drives it. I think you can drive it, it's just she doesn't. She sent a DTPA notice. We don't believe that complied with the DTPA, but we nevertheless engaged in kind of a good faith discussion to see if we could get an inspection of the vehicle under the DTPA. Ms. Cunningham put a number of stipulations on that inspection that were pretty onerous. Just important to note, she's never brought that vehicle back to the dealership to have the service department at the dealership take a look at it. That's typically what you would do, especially in a warranty situation. She claims she has taken it to other dealerships. We haven't seen those records. We've asked for them, but she hasn't provided them. And so what we have requested, which I think is reasonable, is that she bring the vehicle to the dealership service department so that we can perform a thorough inspection just to determine if there is a manufacturing defect. That is something, obviously, if there is, we would put Nissan, the manufacturer, on notice. And so this is the way it always works. I've represented this dealership and a number of dealerships for about 20 years. And for whatever reason, we're getting some real obstinates with bringing the vehicle in. We've even offered to come and tow it and pick it up. And if she doesn't want to drive it up, I've explained to her we have insurance to ensure that anything that happens at the dealership to the vehicle will be covered. But again, there's just been a lot of obstinates. And in fact, she claims that based on what I see from her response, she claims that we're not entitled to an inspection because that's no longer relevant, which I don't really understand. All of her misrepresentation claims are premised on the fact that we sold her this vehicle that we misrepresented was in a good and workmanlike condition, but it has this defect. So what we've asked is to be able to serve 5 requests for production, 5 interrogatories, just to kind of get to the basis and understanding of what's wrong with the vehicle, get the service documents she claims that she has in her possession that haven't been provided, and then just to inspect the vehicle as we're allowed to do under the DTPA. And again, the best place to do that is at the dealership. That's going to have all the equipment. That's going to have the devices that will allow us to listen to the vehicle and ensure if there is a manufacturing defect. So that's kind of what we're asking her. We did file a special exception. We believe her petition was purposely vague and really didn't even mention a defect because she's trying to avoid us being able to inspect this vehicle. She filed a response to our motion for limited discovery where she did admit, yeah, there is a defect in the vehicle. It's making this weird noise. We just need to find out what it is, Your Honor. I think more information here will allow the parties to actually engage in settlement negotiations. And unfortunately, the failure to do that pre-suit, has kind of led to where we are.
All right. Good morning, Ms. Cunningham.
Good morning.
All right, defendants asked for some standard discovery items. So let's go through them one by one. I wrote them down as he went through them.
Okay.
So the first thing he said he'd like to get is a copy of any service documents that you've received as a result of taking your car for inspection with other places or having work performed on it. Do you have those records?
Yes, and Round Rock, has access to the Nissan's National Service History database.
Ms. Cunningham, in a lawsuit, both parties have to give each other some information. I'll just say right away that the things he's asking for are things you would probably need to present to me anyway to win your case. So it may be to your benefit to go ahead and gather those things, let the defendant take a look at it, go ahead and submit it to the court, and then we've all got the same stuff. Because truly, it's all got to be up front. Like, it all comes in advance. So if you have taken your car for inspection or service you should provide a copy of those records to the defendant and to the court as well, because it's probably going to be necessary and important for you to show that. Otherwise, how do you know what's wrong with your car? Right? So you got to give them that stuff. So if you've got them in your possession, that would be something that needs to come over. All right. How about, what production request do you want, Mr. Starling?
I think that essentially I think is about it, Your Honor.
You said you had 5 requests for production.
I think we just asked for a limited number, just, that would be palatable to the court. But I think essentially what we're looking for is any type of documents that show what the issues are with the vehicle. Like if she took it to any, service department at another Nissan dealership, we'd love to see what those documents are.
All right. Things like car washes aren't important, but if you had work done on or inspection about it, that would come in. All right. What specific did you want for interrogatories? Is that the standard stuff? Your name, owner, address?
Correct, Your Honor. Just
right.
some basic contentions and that sort of thing. It's a little bit difficult to understand. Her petition was a little bit vague, I think.
We'll go through
Now,
that.
yeah.
But you could serve limited interrogatories. Ms. Cunningham, you can do the same thing. So typically an interrogatory is a question, a fact, admit that this is true. Please list all of the names of, these are admissions and interrogatories. They're pretty basic things. You are also welcome, if you'd like to do so, you can submit me a list and say, Judge, I want to ask the defendant these questions. What's the name of the service tech? When did you buy, whatever it is you come up with. You can do the same thing. If you are interested in how to find those or some examples of them, texaslawhelp.org is a great website, and you have a consumer case. In there, you can find examples of sample questions to ask in a case like this. And you're welcome to, if you want to do that as well. But all right, we would grant interrogatories, pretty basic. And they're not onerous, Ms. Cunningham. You just write your answer. If you don't know, you don't know. If you do, give what you have. It's not meant to ask you to write essays, though. It's a limited amount. All right. And then the dealership would like to inspect the vehicle. And that seems reasonable to me as well, Ms. Cunningham. Are you able to take the vehicle to the dealership?
So when I first started this, the whole case 8 months ago in August, I stopped driving the vehicle because I was preserving it as evidence in my, this case and another case. And so since then it's, state inspection has expired, the state registration has expired, and Nissan actually also has a safety recall on this car. So I can't drive it anywhere.
Just offer to come and pick it up.
But the only other thing outside of that is they haven't provided any rules or boundaries around their inspection. Just because as I am trying to preserve it for as evidence in another case, is there any way we can line out a, what would that inspection that they have it while it's in their possession, what would that look like?
It's going to be an ordinary inspection to figure out what's wrong with the car. And if you can tell them what you say is wrong with it, that'll limit what they're looking for, right? Like if you say the problem is in the engine, they don't need to be looking in the back seat.
Okay.
Part of what Mr. Starline is asking for is that you got to tell them what specifically is the defect, and then they can go and inspect it and look, is that a defect? Because if I'm understanding correctly, Nissan wants to know if Round Rock Nissan got a bad car from the Nissan, because they also want to get their money back, right? It's not just you, it'd be the dealership that paid for a bum car, and then they've got to deal with all these lawsuits. So taking it back for inspection is a reasonable thing to do.
But sorry, really quickly, can I also add that this specific case is about the representation at sale, not because Nissan North America would be the warrantor. So I'm mostly curious about their certification and inspection process. Did they know about this before they sold it to me?
Ms. Cunningham, please research what your options are in terms of discovery.
Okay.
Okay, because you have, just as Mr. Starline is asking for some discovery as the plaintiff in a case like this, you also can do some things in advance that may be beneficial to you understanding where your position is. I can't tell you what to ask, but please look into what types of discovery you might want to request.
Okay, right. Yes.
All right, then you just send that to me and I'll look at it. If it seems reasonable, we grant it. And I'll also say, Mr. Starline, Ms. Cunningham, if you sent the court request for production or for discovery that on its face strikes me as completely reasonable, I'm likely just to grant it and then send it to Mr. Starline's in his firm. And that is without a hearing. And the reason for that is that Mr. Starline is an attorney. He is used to seeing a discovery request, whereas Ms. Cunningham, you are not. And as a pro se person, that's why we had a pretrial. I want to give you a chance to explain and ask questions. Whereas if you ask me, hey, Judge, I want them to give me a copy of, service records or whatever you come up with, if it's on its face pretty normal, I'm just going to grant it and send it over. Does that make sense, Mr. Starline? You may not get a hearing like this because I don't think it would be, in the court's discretion, we want to make sure parties understand what's happening, and I think you would probably understand the discretion.
I absolutely understand, Your Honor. Just real quick, briefly, I did not realize that there was a separate lawsuit. Sounds like against Nissan. I just was curious if Ms. Cunningham could confirm, because that's good to know. It's something that we'd need to talk to Nissan about, and it may be something where we need to consolidate the cases.
Potentially. Ms. Cunningham, have you filed an actual case against Nissan Motor?
Sorry, say that again.
Have you filed a lawsuit independently against Nissan Motor?
To Nissan North America, yes. Yes.
What court is that case in?
Yours.
What's that cause number?
Sorry.
Actually, I might be able to pull it up for you if it's in the same party name.
Oh, J3CV 260000657.
Yeah. It's Alexa Cunningham versus Nissan North America. She filed that February 13th. So that was filed about 2.5 months after this one. And I'll just give you an update. We were settled for a reset. We were settled for a pretrial on Monday, but our jury trial went all day. We had to reset it. So we are going to have a pending reset date on that. But there is a pretrial coming up, and that pretrial is in response to defendant filed an answer and limited discovery.
Your Honor, I'll just let you know, I think we're going to have to file a motion to consolidate. The way these cases always work is you have to have the manufacturer and the dealer in the same suit.
Yeah.
It sounds like what she's seeking is potentially a double recovery. So, I will, and you said it was, would you mind repeating the cause number again?
Let me go back to it. And I don't know, that may be what we learn a little bit more. It sounds like, if I'm understanding, I think Ms. Cunningham is making a distinction between what she received as the product and a deception in actually selling it to her.
I get it, but
I don't know if those are two independent causes of action.
well,
Correct.
and
I'm definitely not trying for double recovery. It's just I'm just trying for reasonable negotiation and make
Ms.
this right.
Cunningham, have you talked to an attorney about those two specific types of action and about whether they are the same thing?
No.
That's where I can already see where Mr. Starling's going with this. That what I would say is before we have any additional hearings, because there's probably going to be a motion to consolidate here. There's going to be a little bit of time for parties to spend some time and do some research on it. But Ms. Cunningham, that would be, what specifically are you alleging is the breach by one versus the other? If you're saying there are two different claims, really you got to narrow down what is it that you're saying Nissan did versus Round Rock, the dealership. All right. Okay.
But
I can send us more information.
And I specify that one is a warranty claim and one is a representation, like a sales claim. Is that correct? Am I understanding that correctly?
I can't comment. I think that would be getting too far along in the cases.
Well, the issue, I'm sorry, Your Honor.
Go ahead, Mr. Starling.
The issue is they're all premised on the same issue, that this car has a defect. And I think I hear what she's saying. She's separating the DTPA claims against the dealership because we are the ones that are the face of Nissan and sold her the vehicle and potentially made misrepresentations. But they're all premised on the same set of facts, which is this car has a defect. That's why, it would make sense to consolidate in fact, in every other case I've ever had it happen. So anyway, we will look at doing that here probably today. I'm sorry if
let's return to why we're here, because we've got some more information. Ms. Cunningham, thank you. We're all getting a big picture of the story. For today, in 25-3670, which is Cunningham versus Round Rock Nissan, not Nissan Motor, right? We're within the dealership case. For that one, I would grant a production request. Ms. Cunningham, please provide any of the service records that you have related to the current car, right? Anything you had that proves that there's a problem with it or you've had to take it in because of ongoing issues. You would provide that over to the defendant. Defendant is welcome to serve a limited number of interrogatories. And Ms. Cunningham, like I said, you can absolutely request the same from the court. And then I do think an inspection is going to be necessary. At some point, Ms. Cunningham, in both this case and the other one, they're consolidated. It's going to need to be done. If you're not driving the car, and I hear that, and you don't have the insurance on it, Mr. Starline, certainly parties can make a accommodation. This is where I say it needs to get done, but I'm not going to work with y'all to figure out what day and how that happens. So Ms. Cunningham, you're going to be receiving communications from Mr. Starline, and I would ask that parties work together sometime in the next 45 to 60 days, arranging a way for that car to be inspected. And Ms. Cunningham, once it's inspected, that inspection would be valid for both of the lawsuits you have. Okay. Makes sense, like it's all kind of come out of the same situation. All right, court would allow 60 days for all of those things to occur.
Thank you, Your Honor.
All right,
Thank you, Your
good
Honor.
luck to everyone. We will see how this develops, because I can hear a lot of things going on there. All right, all
you.
parties are excused. Thank you very much.
Thank you.
Thank you. Yeah. I wanna go